Welcome, everybody. We are happy you decided to join us today on our webinar on cross-border employment and business. And we want you to provide to you an overview and on the basic principles on residence law and some information on best practice. My name is Sophia Schulte, and I'm today's speaker together with my colleague Adnan Alumerovic. And some organizational information in advance. You have the opportunity to ask questions via the live chat. These questions can only be read by us moderators, so feel free to ask any question you have. Please understand that we might not be able to answer every question. We will try to ask as many as possible in our Q&A section at the end of the webinar. And then we'll see how many questions we will get to. If there are any questions unanswered at the end of the webinar, we are of course happy to get back to you by email and answer any questions that might be left then. Okay, and then let us dive right into. In order to give you some better idea on the topics we want to talk to you about today, we will introduce you to some use cases from our day-to-day work, on which we will then discuss the legal implications on these cases. For this, my colleague Adnan will provide you with an overview on the German residence law, and then we will go into the case analysis, and at the end we will give you some additional information about best practice. Now, to our use cases we want to discuss today. These are some example cases we advised on in our day-to-day practice. The first case is regarding an Indian national who is employed with a UK company, and this Indian national does not have a German residence title or a residence title from another EU member state, and the UK company, the employer, wants now to establish a subsidiary in Germany, and therefore wants to send this Indian national to Germany to help set up this subsidiary. The employee is supposed to come to Germany regularly during a period of 2 months and handle all the tasks that are with regard to the establishment of this new company in Germany. And then we will answer the question if this Indian national we need a German visa or not. Our second case will be regarding a Brazilian national who's employed with a US company, and as in all our cases today, this individual does not have a German residence title or an EU residence title. And this Brazilian national is supposed to come to Germany to undergo some further training within a German company, which is part of the employer's company group. Our third case will concern an US national in this case, who is also employed with the US company, and this US national is supposed to come to Germany to take part in a German trade fair in which the US company will have an exhibition stand, and therefore the employee is supposed to come here and look over the stand. Our last case will concern a Japanese national who is appointed as managing director to a German company, and therefore has to come to Germany on a regular basis to fulfill his obligations as managing director of this German GmbH. And for all these cases, we were going to answer today the question, does this individual need a German visa? And if so, which type of visa is required? And to understand this, my colleague Adnan will now give you an overview on the basic regulations on German residence law. Adnan.
Thank you, Sophia. Welcome from my side as well. As announced, we will go through an overview to German residence law, and there we will have a look about what is to take into account and what does apply for an employment or a business trip under German employment and residence law. First question is, who needs a German residence title, in principle, all persons who are subject to the German Residence Act require a residence title. Who are these persons? At very first, persons who do not have a German citizenship, as well as all the people who who holds an EU nationalship and their family members. These peoples are taken off, and as well as their family members. As well, the German Residence Act does not apply to persons who are not under the German jurisdiction. This means diplomats, their family members, and domestic servants. So for the next few hours, we will go every time in this regard to third country nationals. So all the next steps, all the next things we will discuss, we will see it does apply for third country nationals, not for German nationals and not for nationals of an EU member state. So in this regard, maybe just short idea of the various types of German residence titles, just to have an idea what we're talking about. At very first, visa, in German Visum, is issued by German mission abroad, so there's no option to obtain a visa here in Germany. And we have to make a distinction between national visa, so-called D visa, and Schengen visa. At first, D visa. D visa are issued under conditions, and it's depending on the purpose of the stay. D visas are in generally entry visas, and they're usually valid for 3 months, can also be issued for a longer period. For example, if we got unemployment which is only agreed for 6 months, so it is possible to obtain a D visa for 6 months. But in general, if we just apply for a D visa, the usually validity is 3 months long. Next one is the Schengen visa. The Schengen visa is based on EU law, not German law. Schengen visas are primarily visitor visas. So the idea of a Schengen visa is the people are entitled to come to the Schengen area, but not to work here. No employment purposes are mentioned within this meaning. Schengen visa entitled to visa-free stays. What does it mean? 90 days within 118 days. This is a very important rule. We will have a look later how is the period calculated. The next one is the residence permit, in German called Aufenthaltserlaubnis. It's a temporary residence title issued under German law. So German law applies. There are various purposes: employment, education, political or family reunion. In principle, maybe just to have an idea of only skilled employees, which means university degrees or vocational training, can obtain a residence permit for the purpose of employment. But of course, there's an exemption as well for several nationals. There are options to get on residence permit even if they're not skilled employees. But it's always an assessment on each case, and so feel free if you have such a case to contact us. Further, there are EU titles as well, a Blue Card EU and ICT card. We are quite sure you already have an idea of what does it mean. But here to get always the parallelity of we have the German resident titles and the EU resident titles. The Blue Card EU and the ICT card, the main important things are they're temporary, so they're not permanent residence title. And the ICT card is very important, can only be obtained abroad. So there's no option to get an ICT card here in Germany, even if an employee is already in Germany. And at the very last 4 hours, I got an overview about the types of German residence titles. The permanent resident titles here are two types of, one called the permanent residence title, Niederlassungserlaubnis, and the permanent residence Permit EU. It's in German der Daueraufenthalt EU. In any case, an individual who holds such a title is entitled to stay permanently in Germany with the permanent residence permit EU. He's even entitled to stay permanently within the EU. So if for one person both options are possible, he should consider what is more favorable to him. Let's go to the next slide. Who needs a visa for Germany? So we know the types, and now we go in detail who needs really one. There is a general rule: third country nationals need a visa when crossing the border of an EU member state, respective the Schengen area. Examples are Russian, Chinese, or Indian nationals. But also here's an exemption as well. Third country nationals could be entitled to visa-free stays. What does it mean, visa-free stays? The people are entitled to stay 90 days within 180 days if they do not have employment purposes. So if they only want to stay for visiting purposes, they can stay the whole period of 90 days within 180 days. If they intend to perform unemployment and within the meaning of German residence law, they need a visa. That's the main fact. But here are some exemptions as well. We will get to them. Examples for nationals who are entitled to visa-free stays are US nationals and Japanese. And then we have persons, third country nationals who already have an EU member state residence title. They are entitled to stay in Germany for 90 days within 180 days. That's the so-called visa-free stay, Schengen stay. This all is based on Schengen law, on EU law. Then, as mentioned, there's some specific employment within the meaning of German residence law, and a so-called non-employment fiction, in German Nichtbeschäftigungsfiktion. But at first, the principle. A third country national does need a German residence title for the purpose of employment. We will call it here work visa. It's to have an easier wording for, because there are several types as seen, but not to distinguish between visa, residence permit, blue card, and so on. We will only use the term work visa. So we are not quite. We will be more in a range when we say work visa. But there are exemptions for when a person does not need a work visa, and it's called the Nichtbeschäftigungsfiktion. That's quite unusual rule, because just within the German residence law, unemployment is not considered as unemployment, but under German employment law, under German security law, they are considered as employment. So just for residence law purposes, they are not considered as. So it's called Nichtbeschäftigungsfiktion. The non-employment fiction is generally determined by the duration and the type of activity in Germany. To have some ideas of, we prepared some cases. So at the very first, the type of activity: executive employee. The employee must fulfill company-related management tasks in Germany with own considerable scope of decisions. It's quite general. So here is an individual case assessment necessary. We have to check whether the person is really an executive employee. In Germany, it's called leitender Angestellter. So it's not just easy to say, somehow is doing or is fulfilling this task, so he's in any case executive employee. We have to check it in an individual case. Another thing is the legal representative of a German entity. For example, a managing director of a German GmbH, Geschäftsführer einer GmbH. These people, this activity is applied by the non-employment fiction. The duration of a person who is performing such an activity as an executive employee or legal representative, he is entitled to perform this activity for 90 days within 180 days without being considered as an employment. That's the quite thing here. So managing director, we will see in the use cases, is entitled to come to Germany to perform his tasks within 90 days, within 180 days, and it's not considered as an employment within, that's the point, German residence law. So there are another activities as well, so-called business trips. One very important point is here for an employer, so not for a German employer. That's really important. So the activities are mentioned: conduct meetings or negotiations, prepare contract offers, conclude contracts, or monitor the implementation of a contract, or establish, monitor, or control a domestic business unit. Domestic business unit does mean a German business unit. So this is especially for the cases if a group company wants to establish or to buy some unit in Germany, they can second their employees. The duration herefore is 90 days within 180 days. So if an employee is to be seconded to Germany to perform one of these activities, and for 90 days within 180 days at the maximum, this activity is not considered as unemployment under the meaning, within the meaning of the German residence law. Another type or another case of the non-employment fiction is a skilled employee who of course is employed abroad by a foreign employer for the purpose of further company training. This means he can be a participant or he can be a trainer as well. Important here, he really has to perform this company training. If he is just like, okay, he's seconded, and we will say formally he will be participating on our company training, but he will be working, he will perform normal work. Then it's not considered as a non-employment fiction. So the only purpose of the secondment has to be the company training. There are no other purposes allowed for. The duration herefore is 90 days within 12 months. So we see here for this activity, employees are not entitled to stay just 90 days within 180 days, but 90 days within 12 months. So, and the 12 months has to be calculated accordingly to the 180 days period. We will take a look. On how to calculate this period. The last case for today, which we will discuss, is an employee employed by an employer based abroad. Again, and this employee is to be seconded to Germany for realization of contracts for the supply of works, assembly of machines, dismantling, and supervision of company-owned exhibition stands. Here is another important point. If we got such an activity, there is a requirement to notify the Federal Employment Agency, Bundesagentur für Arbeit, of the activity. So even it's not considered as an employment. So if he's entitled to a visa-free stay, he could come and perform this activity. There is a requirement to notify the Federal Employment Agency. So there's as well somehow a little to-do act, and not just like a foreign visa and not so bureaucratic for a visa, but there are requirements. The duration for this activity are 90 days, again within 12 months. So if we have one of such a cases, we have to examine which case we have, and how long is the person entitled to stay, not to be considered as unemployment within the meaning of the German residence law. So here are individual case assessments required. And now to the last, a few times already mentioned how to calculate 90 days within 180-day period. The relevance is apparently for visa-free stays and non-employment fiction. And there is a backward calculation. What does it mean? At very first, we have to take the planned date of the departure. And from, for example, if we go for the 30th of May, and from this day, we have to count 180 days back. Days. We can't say months, really days. So after we got the 180 days period, we go to the 90 days. For the 90 days, we count every single day, even the day of entry and the day of departure, even if maybe an individual is coming to Germany at 11:30 p.m. So he is just for half an hour in Germany this day, but this day counts as a whole day. That's very important. So we count every day he is in Germany or the Schengen area. This is very important for all the people who are traveling around Schengen for visiting purposes and so on. For example, if we got a US national who says I want to have nice holidays in Croatia, so I will stay in Croatia for 6 days and then I will go to Germany to perform my tasks. These Croatian days are considered as stays, so they have to be calculated and take into account for the 90 days. So there is one big risk. For example, if we got on time schedule, for example, we have checked a person who is to leave Germany on the 30th of May, but then it shows we have to reschedule his departures, so he will leave on the 5th of June. The 180-day period has to be calculated at a new, so because the whole period changed, and this system, how it goes, it's called rolling period. So we have always to check on which day is it planned and will the plan be performed as planned. If there are some changes, the 180-day period will change as well. So these are the points which has to be considered when checking if a person or if an employee is entitled to come to Germany and whether the non-employment fiction applies. So a lot of things. We hope new things, but to get more practical, we prepared the analysis. And so, Sophia, please provide us with the analysis. Thank you very much.
Yeah, thank you, Adnan. Okay, so on the basis of what Adnan just mentioned in his part, we developed this third question system to figure out in each case and to review if a foreign employee who is to come to Germany for a limited period of time, whether this individual needs a visa and which type of visa. So the first question you always have to ask yourself, or we have to ask is, what is the nationality of the individual coming to Germany? And is this individual, based on their nationality, allowed to come to Germany or the Schengen area visa-free? As Adam already said, in principle, every third country national needs a visa to enter Germany or any other EU member states, but there are exemptions depending on the nationality. There's a very comprehensive list of the nationalities who are exempt from this visa requirement and who are not. which can be found on the websites of the German authorities. It's a very long list, so we did not include that in here. If we decided this national does need a visa, there's also the option that he already has a residence title from another EU member state, which can function as a permit to enter Germany as well. So this is then one step you have to take as well. In our cases, we will discuss today, none of the employees has such EU residence title from an EU member states. So this will not be the case. So we will not be discussing this today. But the next question, after we decided whether or not a visa is in principle necessary based on the nationality, we were going to see how long is this individual, this employee, supposed to stay in Germany. Is he really stay no more than 90 days within this 180 days period? A visa may not be required, but if it's already from the start clear that this employee will stay for more than these 90 days within 180 days period, then a visa is most likely required. So in this case, it should be, if you have this case on your desk and you have to decide this, this is the part where you need to really look into it if it's required or not, but in most cases it will be required here. And then we have to, after we have a look on the nationality of the employee and how long he's going to stay in Germany, we will see what kind of activity is he supposed to do in Germany. Can these activities fall under one of these options for the non-employment fiction, or is it does this non-employment fiction does not apply, and therefore it is considered employment within the meaning of the German residence law, and therefore this individual needs a work visa to perform these tasks. If it's just if somebody just wants to come to Germany for holidays, of course, they can do that no matter within these 90 days, within 180 days, regardless of what he wants to do here, if it's just for fun. So with this in mind, we go to our 4 cases we discussed at the beginning, and we'll see how this translates to these cases. So in our first case, we have this Indian national who's employed by this UK company who's to come to Germany to help set up a German subsidiary of the UK employer. So our first question is, what nationality has the employee concerned? As this is an Indian national, he is not exempt, or they are not exempt from the visa requirement, and therefore they need in any case a visa to enter Germany or enter the Schengen area. And the next step would be to see what kind of visa is he required to apply for. Will a Schengen visa suffice, or is it necessary to apply for a D visa? And a Schengen visa in this case is sufficient as one of the non-employment fiction applies. So these activities the employee is supposed to do in Germany are not considered employment under German residence law. Because in section 16 of the Beschäftigungsverordnung in German, it's the employment ordinance in English. There's these exception, as Adnan already mentioned, for business trip activities, which also includes every activity that is necessary to set up or establish a German entity or branch of a foreign company. So, for example, the purchase of a share company, the registration with the commercial register, or any other public registration that are needed, concluding the lease agreement for the office of the company, hiring employees in Germany, etc. All these activities that can be considered as part of the establishment of a German entity or branch are considered non-employment, and therefore a Schengen visa suffices in this case of this Indian national. In our next case, we have a Brazilian national, and he's to come to Germany to do some further training, some company training at a German company, which belongs to the same group of companies as the employer company in this case. And again, in this case, we are asking the three questions. So what nationality does the employee has? He has he's a Brazilian national, so he is entitled to come to a visa-free stay. So he doesn't need a Schengen visa at all to enter the Schengen area for 90 days within a 180 days period. And this employee will stay within this deadline, this period? With our next question, and again, yes, he will stay for no more than 90 days within a 180 days period, because he's only come to Germany to perform this further training for 2 months. And then we have the asked question, is this considered, this further training, is this considered employment or not? Is a Schengen visa sufficient, or would we need to apply for a work visa, a D visa in this case? And as Adnan mentioned, the participation as a trainer or a trainee in a company training within the same company group of companies is also a case of this non-employment fiction in accordance with Section 17 Beschäftigungsverordnung, and therefore this employee can come to Germany for 2 months based without needing I was confused, I think, without needing a visa at all, because he is a national that is exempt from the visa requirement. Of course, in cases like this, where no visa is required for the individual to come, there is always a risk that the assessment of the task to perform in Germany really fall under the non-employment fiction or not, because this is always this needs always to be reviewed on a case-to-case basis, and as no visa application process is needed, there's no authority will be checking if these requirements really are fulfilled for the non-employment fiction or not. So it should be always been done, as you should always do this quite carefully and really check if all the activities here that are supposed to be done in Germany fall under this non-employment fiction. In this case, as Adnan already said, all activities that are necessary for this further training, so listening to some lessons, even do some practical training, all these activities are included or fall under this non-employment fiction. However, if the employee should after maybe this 2 months stay for another week just to work at the German company, this would not be covered by this non-employment fiction. Therefore, a German work visa would be required for this additional week for this employee. With regard to our third case, in which we have a US national who's employed with a US company, and the employee is supposed to come to Germany to look after the exhibition stand of the US company at a German trade fair. We are always also asking us the same questions. US nationals are entitled to a visa-free stay in Germany. As the employee will only stay in Germany for 2 weeks, this is within the 90 days time limit, so we have no problem there. And then we have to check again whether a non-employment fiction applies, which is the case for the participation, the active participation in an exhibition at a trade fair in Germany for the exhibitor under Section 19 BeschV, with the activities that include like setting up and dismantling the exhibition stand, and also attending, of course, to visitors at the stand, telling them about the business, etc. All the activities that fall under these requirements can be considered setting up or dismantling the exhibition stand or attending to the visitors are covered by this non-employment fiction. also the visitors of a trade fair. So only if you don't have like your own exhibition stand, but you're only interested in that, and your employer company is interested in that, and the employee is to send to Germany just to attend the trade fair as a guest. This is also possible, and this would fall under the business trip activities for attending meetings and maybe even negotiate contracts at the German trade fair. This is also covered by this non-employment fiction. Also in this regard, it's always necessary to be very careful, and with every activity these employees are supposed to do in Germany, if they fall under these unemployment fiction or not, because maybe it can be decided on the spot that an employee should stay for a little longer and maybe work in Germany or do any other activities. In this, if this is the case, it's always necessary to review again and check again whether all the other activities also fall under the non-employment fiction or not. And our fourth case, with the Japanese national who is appointed as managing director at a German GmbH, and who is supposed to come on a regular basis to Germany to fulfill his duties as managing directors, to make decisions regarding the company, maybe sign some contracts, etc. Also, in this case, we will ask our 3 questions. Japanese nationals are also entitled to a visa-free stay. The employee will stay no more than 90 days within a 100 days period. This has to be, of course, for every stay, for every time the employee or this Japanese national comes back to Germany, needs to be reviewed again if we are still within these 90 days in this 180 days period or not. And as the employee here is the legal representative of a German entity, he falls under the non-employment fiction under section 3 of the BISchV. So he can do every activity that is necessary in his position as managing director. But of course, also here it's important to check whether the activities in Germany are still connected with this position as managing director, or maybe if the individual has a second employment and wants to do some task for this employment in Germany, then these activities wouldn't fall under this non-employment fiction. And now some information on best practice, how to apply for a visa if our review has come to the conclusion that one is necessary. So usually, as we already mentioned, the visa needs to be applied for at the competent German mission abroad. So the third country nationals can't come to Germany to apply for the visa here, but they have to do it in their home country before entering Germany or the Schengen area. As we talked about today, there are exemptions from this. For like visa-free stays are possible for certain activities, and this should always be checked before entering Germany if one of these exemptions apply or not. And if a visa is required, it also needs to be checked what kind of visa is required. Is a Schengen visa sufficient for the length of stay and for the activities to be done in Germany, or is a D visa, so a work visa, some type of work visa necessary? As we already said, Schengen visa is only sufficient for work activities that fall under one of the non-employment fictions. Otherwise, a D visa is required. The procedure is always that the employee concerned needs to make an appointment at the company, at the competent German mission abroad, and apply for the visa and submitting all the required application documents. Information on that can usually be found on the website of the missions abroad. However, there are, of course, nowadays often the option to apply for Schengen visas online only, and so that no appointment is needed. But this is very dependent on the country and maybe even the third-party provider who handles all the Schengen visa applications. So this should also be checked in advance. If this third country national comes to Germany for activities that are considered employment, the third country national would, after his arrival in Germany, also have to register at the relevant residence registration office and apply for his residence title, so his more permanent work visa, at the relevant immigration office, which would then issue the work visa in form of an electronic residence title with this little check card, maybe few of you know, to show that they are allowed to work in Germany. Who's responsible for what in this process? It's important to know that there are some tasks only the employees can fulfill. There are some tasks the employer is responsible for. So, of course, all the provision of all the necessary documents, the personal documents of the employees, the identity documents, certificates, qualification certificates, proof of German language skills if necessary. All these documents are considered like tasks of the employee, of course, and the employer's tasks are often only like supporting tasks, like if there's like a confirmation of the purpose of the stay needed, like an invitation letter, or for the business trip, or some if there's, for example, the employee is supposed to do some further training in Germany, some company training, the provision of a training plan and all which is necessary for this needs to be provided by the employer. Also, of course, supporting maybe with making appointments and helping with and supporting with preparation of the application documents. So often the documents are only available in German for some of the documents. So maybe needs some translation to be done for the foreign employee. And so this is something the employer can help with. And as a rule, in principle, it's common that the employer also covers the costs for the needed work visa or Schengen visa, which in principle is not that much usually. So it's normal that the employer covers these costs. And if from the perspective from the German company, for example, if a foreign employee is seconded from their foreign employer to a German company, for the German company, it's important to know that they are not allowed to employ any third country national without them providing some residence, providing them a copy of the residence title. If one is needed, if one is not needed, the German employer should get this a confirmation from the foreign employer or from the foreign employee that one is not needed. Usually, this can be, for example, done by the legal opinion of a lawyer, or who said that a visa is not necessary. Because according to the law, German employers need to, before employing foreign third country nationals, verify the existence of the residence title, and they also need to keep a copy of the residence title throughout the whole employment relationship, and they also need to notify the immigration office if such employment ends. So this is important for the German companies to keep in mind. Why is it important to keep in mind? Because there are harsh fines that may be paid if foreign employees are employed in Germany without the necessary visa or residence title or residence permit, as this is considered illegal employment. So, and this could be for the employer, can be fined up with a fine up to 500,000 euros. And this also can be entered in the Central Trade Register. In addition, it might even be a criminal offense, which can be punished with a prison sentence up to 3 years or a fine. So it might even be some criminal liability there. In addition, if the same applies if, for example, an unauthorized employment of foreign of third country nationals, if these are employed in Germany with worse working conditions than are usually granted in Germany, and there can also be a criminal offense. So even if the employee does not have an employment contract with the German company but is seconded there, this should also be always be kept in mind if maybe the activities of the foreign employee may be considered an employment in Germany. And also for the employee, there are some risks because they can expect a fine up to 5,000 euros if they are working in Germany without the necessary visa or residence work visa. If they do this again and again and are caught again and again, there's even the possibility of a criminal offense. And of course, if they are, it can be harder for them to get a visa for the next time they want to come and they apply for a visa if they have been caught not complying with the German residence law in the past. So it's always important to check whether this visa is necessary and not to let foreign employees work at a German company without them providing either the residence title or some information why a visa in this case might not be necessary. And now we will happy to answer some questions. I don't know, Adnan, if you want to begin.
There have been reached out some questions. Thank you very much at this point. One question is based on a normal, we assume D visa, a person is not allowed to perform employment. Is it right? We have to check which kind of purpose the D visa is issued for. If the D visa is, as usual, issued for employment purposes, of course, the person is allowed to perform work. If the visa is, for example, issued for family reunion, it could be, as usual, the person is entitled as well to perform employment. If the D visa is issued for another purpose, we have to check. So this is a case-to-case decision, and an individual assessment is needed for. So we hope this answer may help you. Another question is, what options are available if a person holds a residence permit in one EU country but is to be temporarily or permanently assigned to work in another EU country? Very good question. At very first, a person who holds an EU national residence permit is allowed to visa-free stays in Germany. So the person is allowed to stay 90 days within 180 days in Germany. Whether the person is allowed to perform employment, it depends on whether the non-employment fiction applies. If the non-employment fiction applies, the person is entitled to perform this task. But as we have seen, a non-employment fiction only could apply for a really short time, 90 days within 180 days or within 12 months. So if we are checking the question whether a person is to be seconded for a longer term than 90 days, he will need a German national visa. And there are as well some exemptions possible. For example, if the person holds an permanent residence title EU in each or in the respective member state, so there could be some easier possibilities to get him here in Germany and to obtain here a German national residence title. But in any case, as a rule, you can take here from, yeah, he needs a German residence title, and he is not entitled to perform his employment or his task for a longer duration than 90 days.
Yeah. Just to maybe add to that, so as Adnan already said, it really depends on the kind of the type of the residence title this individual has in the other EU member state. If it's a national residence title or if it's an EU residence title. In addition, it also depends on what type of work this employee is supposed to do in Germany. For example, if he's supposed to come to Germany to provide services under a service agreement that is concluded by his foreign employer and a German company. There's this type of visa called Van der Els visa. This could be applicable, but this is something we would have to review if we have more details. There are some options for this employee, but it really depends on the case and really what are the basis of the case. But of course, we are happy to answer this in more detail if you reach out to us after this webinar. And I think, Linda, it's also your second question, which is how is this situation legally assessed when an invitation letter explicitly mentions assembly work, but only a Schengen visa is issued, leading the non-EU company to assume that the visa permitted the individual to perform work in Germany. So I'm not quite sure if I fully understand this question. If the invitation letter mentions assembly work and this employee is supposed to do some assembly work, he might be allowed to do this based on the Schengen visa. If he is to assemble some machines or some systems that were sold by his foreign employer to a German company, and he's come to Germany to assemble this, then a Schengen visa is sufficient for this type of work, for the assembly work, but not for other types of work. So the employee wouldn't be allowed to do other types of work. And if there was some confusion about this, and this happened, and the foreign employee did also perform some activities in Germany that are not covered by this non-employment fiction, then we would recommend that this employee stop this working and goes back to, or only do the assembly work, and then after that goes back to his home country and not do any activities that are considered employment in Germany without having a residence title for that, a work visa for that. As we mentioned, there might be some harsh fines in this regard, and there could always be like an audit at the German company, and they would find out, the authority could find out this. So we highly recommend staying within the assembly work for this employee. Okay, I think these are the questions we have at the moment. If you have any other questions, even if you have it in German, please feel free to send that in as well. If you prefer us to answer some question in German, we're of course happy to do that as well. We will wait a few minutes if anybody has a question left. If no other, do we get the presentation? Yes. Yes, we will send the presentation afterwards. So you will get all the information in the presentation and some additional information on NÖR and on our global mobility team here at NÖR, and of course our contact details. So you can, if you have like a question afterwards that comes up afterwards, or an individual case you need to be assessed, please feel free to get in touch with us. Okay. I think we're just going to wait a few more minutes or seconds if anybody else has questions. If not, thank you very much all for attending. I hope this was informative for you. I know it's a topic that might be quite confusing because of all the different types of visas and residence permits, etc. but I hope we could give you a little bit of an overview and make you aware that there are types of work that can be done without a visa in Germany, but mostly one is required. So that you keep that in mind before having foreign employees in Germany to perform some work. Okay, I don't think there are any other questions. So thank you very much. As I said, have a great day, and we will see you at the next webinar we're holding. Thank you.
Take care. All the best.